Good morning again, and welcome to the JRG Advisors webinar for the start of a new year in January here. Our topic today is Since You Asked. I'm going to go ahead and mention that you'll receive a copy of the PowerPoint, the recording of the PowerPoint, and a copy of any answers to questions that you ask after the presentation is done several days after today. As a reminder, you can go ahead and send questions to us during the actual presentation by typing your question in and then hitting send. I want to go ahead and welcome to all of those who are participating, who are considered our valued clients and partners, and we have them listed here. So, since you asked, again, this is kind of like a novel presentation today. What I've done is taken questions that I've been receiving from clients and my internal clients here at the office, the salespeople and consultants, and try to pick some interesting questions. And I try to go ahead and vary the topics. So we're going to be looking at several questions under ERISA, the ACA, health reimbursement arrangements, COBRA, and then Medicare secondary payer rules. So let's start out with the first one. Is our employee assistance program subject to ERISA? Now, among all the benefits listed in the ERISA plan definition are things that provide for medical, surgical, or hospital care or benefits. Now, medical is defined very broadly to not only include major medical benefits, but also dental, vision, prescription drug, and an array of other benefits. So a plan providing medical benefits is subject to the general compliance obligations under ERISA. But besides ERISA, we have to also look to see, is this medical plan also considered a group health plan? Because if it's a group health plan, it can also be subject to another set of federal laws, such as COBRA or HIPAA or group health plan mandates. Now, when I said there is an array of other benefits that could be ERISA plans, it would be, or group health plans, it's because they provide medical care. So let's just think for a second, what could they be? And as I mention them, I want you to try and think about how do these programs provide for medical care? So let's think about physical exams, or health flexible spending accounts, or health reimbursement arrangements. What about executive medical reimbursements? Drug or alcohol treatment programs, wellness programs, and the one I love, on-site clinics. So, but our question is about employee assistance programs. And we have to analyze whether the assistance program provides for medical care. Now, we know that many employers are providing assistance programs, and they could be for maybe marital or family counseling. They could be help with stress. Maybe there's financial planning or retirement planning going on. So again, our analysis has to be, what kind of EAP? What does it provide? So if it's financial planning, we know that technically that's not medical care, so that wouldn't come under ERISA. But some of the other ones could possibly do that. And then the next thing we have to consider is what the Department of Labor has told us. They said that if to the extent the EAP provides medical care, it will be an ERISA plan. So again, our analysis has to go with, what does our EAP do? So if our employees, when they call the EAP, and the person on the end of the other line says, I have a list of doctors, call one of those doctors. That's really just a referral service. That's not providing medical care. So that wouldn't be subject to ERISA. However, if one of your employees calls and the person on the other line says, you know, we might be having some problems here, maybe you need a prescription, I'll get something sent over to you, then we're giving medical care, medical advice there. And that type of EAP would be subject to ERISA. So you're going to get the best legal answer I can give you. Is the EAP subject to ERISA? The answer is, it depends. So the next question I have is, can an employer waive the waiting period for a particular employee? Now, for those of you who have been listening to me for the past year, whenever I discuss ERISA compliance, I always mention the plan document and Summary Plan Description, known as the SPD, and how those two documents are the main vehicle for participants to learn what the terms of the plan are, especially terms like eligibility. What criteria does the employee have to meet so that they can receive the benefit? And then also participation. What does the employee have to do to continue to be eligible under the plan? Another fact that I always mention is that generally the employer is the named fiduciary for an ERISA plan. And the main duty or responsibility of a fiduciary is to govern the plan according to its terms. And we know that if a fiduciary does not follow the plan terms, it could be considered a breach of a fiduciary duty. So in answering our question, if the plan term says you have to have a waiting period of 60 days, and the employer says, oh no, I really like that shirt you wore today, so you can go on the plan today, the employer hasn't governed the plan according to the eligibility terms or participation terms. And if an employer did not get an in-plan document, so that would be a breach of duty, and again, so they're not meeting their requirements. Now, the other thing that we have to consider is that in your plan document, there could be language that says the employer has discretionary authority to interpret those terms. Well, maybe 60 terms to me may mean 1 day or the first day of employment. The employer has to be really careful because they can be scrutinized when they're making these types of decisions using this discretionary authority, because sometimes their decisions could be considered what's called arbitrary and capricious. Really no sound foundation for making that decision. Or the decision could be scrutinized under other federal laws. Does the decision of the employer violate the Civil Rights Act, Title VII? Does it violate the ADA or the Age Discrimination Act? Maybe we've said to a younger employer, yeah, no waiting period, and someone who's older, hey, you've got to wait those 60 days. So again, we have to be very careful when we look at that, and if we also want to go ahead and say, I'm going to use discretionary authority. Now, in the questions that I get from employers, I seem to receive a lot of what's called special enrollment questions. Now, this question says, does an employer have to permit a special enrollment if notice is provided 40 days after the qualifying event? Now, generally, the rule of thumb is that an employee who does not enroll when first eligible must wait until the next open enrollment period unless there is something called a qualifying event. Now, this qualifying event language references the portability rules under the Health Insurance Portability and Accountability Act, known lovingly as HIPAA. The portability provisions state that if an individual waives coverage under an employer's group health plan, and the reason for waiving coverage is due to having other health care coverage, then that individual would have a special enrollment upon a qualifying event. And there's basically 3 reasons why you can have a special enrollment. And the first one we're going to talk about, and they're very narrow exceptions or reasons. The first is that loss of other coverage. So if an employee or dependent becomes eligible, if an employer or dependent says, I'm not going to go on the plan now because of my spouse's coverage, and then they lose that spouse coverage, that's a loss of coverage, and it provides a special enrollment for the employee and the spouse. And the second reason there could be a special enrollment right is if the employee or dependent becomes eligible or gains eligibility for a premium assistance program under the state, which would either be Medicaid or what's called a CHIP program for a child. And then finally, another qualifying event would be that if an employee who waives coverage gains a dependent, a spouse, a child, which includes a child placed for adoption or a child adopted, they would have a special enrollment right. Now, HIPAA provides that the individual must give the employer notice of a special enrollment right within 30 days of the event happening. Now, a plan can make, and then one exception here, when it's state premium assistance availability, HIPAA provides it's a 60-day notice. However, a plan can say for all reasons it's 60 days or longer. But we have to be careful because if an employer wants to make that extension, they have to make sure that the insurer permits it. Now, why we need to be careful is because if as an employer you did not give the employee the required special enrollment rights notice, then this could lead to additional claims by the employee. So besides saying, hey, you didn't tell me that I could come on the plan because you didn't tell me about the special enrollment rights, and now I have claims costs, they could collect those claims, they could get enrollment. But also they could collect what's called an excise tax, or an excise tax could be imposed. And that's $100 per day for every day you did not provide that notice. So something else I want to mention here is, technically, HIPAA is not applicable to what we call an accepted benefit. And generally the accepted benefits we look at are health flexible spending accounts and limited dental and vision plans. However, we do know, so you don't have to provide HIPAA special enrollment for those types of plans, but we do know that many insurers will go ahead and permit it. So in answer to our question, do I have to give them a special enrollment if they tell me within 40 days after the qualifying event? Again, the answer is it depends. If you gave them their notice and said the employee has to give notice within 30 days, you can then go ahead and say, nope, you didn't meet the 30-day requirement. However, if you didn't give them notice and they come within 40 days, the answer is probably yes, because you didn't notify them of their rights. So this next question I think is interesting because when I received it, it reminded me that even I have to really sit back and take time and read the question and make sure I'm reading what I think I'm reading and ascertain what's being asked. Because the question is, do employees have a right to examine plan-related documents without submitting a written request? And my first impulse was to say, yes, we put in our plan documents, you have to go ahead and put the request in writing. However, again, when I reread it, it says to examine the plan documents, not to receive them. Because we do know that ERISA says that for an individual to receive a copy, the request must be in writing, and then it has to be provided within 30 days. However, if a participant comes and says, I want to look at the plan documents or examine, then no writing is required. So ERISA says the plan administrators must make the documents available at certain locations for participants and beneficiaries to examine. And these documents include the plan document, the summary plan description, the summary, any summary of material modifications known as the SMM, the summary of benefits and coverage, the Form 5500 if you're large enough to file that document. If you're a part of a trust, any trust agreements, any type of collectively bargained agreements, and actually any contracts. Those are all documents that a participant has the right to examine. Also, the documents have to be current and ready at all times, and they have to be ready at the principal office of the plan. Now, where we have to be careful is sometimes you as employers, you have multiple sites. You may have 5 locations. The documents have to be available at every location you have as long as the site has 50 or more participants in the plan at that site. So another question that continually comes up through that has come up throughout my career, and I've received it from all sizes of employers, both big and small, is an employee out on workers' compensation required to be left on the group health plan? So our first analysis has to start with that we realize workers' compensation is a state statutory requirement. And the requirement to either offer coverage or when you do offer coverage, continuing it, falls under ERISA and also under the Affordable Care Act, which are federal laws. And ERISA is the federal law that has the right to govern the entire field of federal benefits. Thus, a state statute, such as workers' compensation, cannot override the federal law ERISA. This is called preemption. So again, a state law really cannot preempt a federal law. Now, even though ERISA does not require the provision of health care coverage, at this time, the only law that does do that is the Affordable Care Act, and based on what we saw Congress do last night, we're not sure how long this is going to be around even. So let's kind of recap here. So if you do offer a health plan, and an employee goes out on workers' compensation, the employee still has to meet eligibility requirements. You may have a certain number of hours or a certain position. And also, the employer still has to comply with any other laws. So let's talk about another law, the Affordable Care Act, just for 1 minute. If you are a large employer, an ALE, if you have 50 or more full-time or full-time equivalent employees, and you have an employee who goes out, if you measured them as a full-time employee in your measurement period, then they have a right during what's called the corresponding stability period to be covered under the plan, even if they go out on workers' comp, as long as they are considered an active employee, meaning they're not terminated. Now, if the employee does not return to work after the end of that stability period under the Affordable Care Act, that would be a reduction in hours, and then you would offer them COBRA. On the next slide, we're continuing with our question. And the next act or law, federal law we want to consider is the Family Medical Leave Act. So again, if you're an employer who has at least 50 employees in 20 weeks in the current or preceding calendar year, you're subject to family medical leave. And what the Family Medical Leave provides, it says that if an employee goes out for a serious health condition of their own or of certain family members, that their health care, first of all, they can get 12 weeks of unpaid leave, but also their health care has to be provided in the same situation or circumstances as if they were an active employee. So again, here we are. We have to look to say, are we an employer? Are we subject to family medical leave? And if an employee goes out on workers' comp, they would have a right to at least 12 weeks of family medical leave and right to their benefit, their health benefit. If they don't return, again, they would lose their coverage. There would be a reduction of hours, so they would be offered COBRA under that situation. So on the next slide, let's talk about a smaller employer and employees going out on workers' compensation. So you're not subject to the ACA or family medical leave. What we have to look at when someone goes out on workers' comp is the terms of your plan as to eligibility. So does your plan say if you're a full-time employee working 40 hours, then you're eligible for the coverage? Well, if I go out on workers' compensation, I may still be counted as a full-time employee, but I may not be working 40 hours, so I wouldn't be eligible for the health care coverage. Or does our plan say that you have to be actively at work to go ahead and get that coverage? So again, if the employee is not meeting the terms and conditions of the plan as to eligibility and participation, then they would not be eligible, even if they're out on workers' compensation. What I hear a lot is, and I've literally had this, well, the employee's been on the plan and on workers' compensation for 2 years now. So if you leave them on the plan, even though they're not eligible, again, we talked about this briefly, that could be a breach of fiduciary duty. You haven't followed the terms of your plan here. You haven't been treating other employees fairly. And also the other consequence could be that the insurer could say, this individual was never eligible to be on there, and we pay benefits. We're taking those benefits away. So now you're going to have a problem with your employee, with your insurer. And believe me, if they're out on workers' compensation, that employee probably has talked to an attorney already. So you might have some other problems going on there. We also have situations where the employer would say, wait, I have a policy that I say to my employees, you go out on workers' comp, I'm going to let you continue under the health care. Well, again, the employer, you cannot institute or establish a policy that's going to fly into the face of the contract that you have with an insurance carrier. So again, as an employer, you just can't go ahead and create a policy because for one thing, the insurer may say they're not going to agree to it. If you're self-insured, the stop-loss carrier may not agree. And again, then you have opened up another can of worms for yourself. So basically, again, no clear-cut answer. We have to look at the facts and circumstances. But we do know if someone is out on workers' compensation, not eligible for family medical leave or under the Affordable Care Act, and if your health plan is not, if they're not eligible for the health plan, then they should be offered COBRA if you're an employer who has 20 or more employees, and that would be due to a reduction in hours. Now this next question, I like it, only because this is the only one that I've found that I can come out and say yes or no to it. And the question is, can you please confirm if the IRS has extended the distribution deadline for Forms 1095-C and 1095-B from January 31st, 2017 until March 2nd, 2017? And the answer is yes. That deadline has been extended. It was extended and published under IRS healthcare tax tip in 2016, and that was as of December 28th, actually. A word of caution, though, is, and what's interesting, the deadline for furnishing the Form 1094-C or 1094-B to the IRS has not been extended. So here you have to give the forms to the IRS by February 28th, but you don't have to give the form to the employee until March 2nd. Again, that's how our government works. Our next question, continue with some ACA questions. Do you have to file a 1095-C for a health reimbursement arrangement? And just a little bit of background for this. Remember, we file 1095-Cs to our full-time employees to show that, first of all, that they may have had what's considered minimum essential coverage, and that the coverage that we offered was affordable and provided minimum value. Generally, a health reimbursement arrangement will provide for minimum essential coverage, but it generally does not provide for minimum value. So that's what we're talking about here. Now, an HRA is self-insured, again, provides MEC. And enrollment in the HRA has to be reported under Section 6055, which brings around that Form 1095-C, in the same manner as any other enrollment in minimum essential coverage. Now, we have some exceptions here. And why do we have exceptions? It's because when the IRS was looking or developing regulations, they gave us really conflicting information for the first 2 years. First they said, yes, you have to do it. Then they said, no, you don't have to do it. And then they said, maybe you have to, but you might not have to. So now in their instructions in the 2016 forms, we definitely have clear guidance, and they provided that if an individual is covered by 2 or more plans or programs that provide minimum essential coverage, and if they're provided by the same reporting entity, then you only have to give one 1095-B or 1095-C out. And the other exception is if an individual is eligible for an HRA because the individual is enrolled under an employer's insured group health plan, for which the Section 6055 has to be met, then generally reporting for the HRA is not required because that plan is considered integrated. Now, it's only applicable if both types of coverage, the self-insured HRA and the fully insured group health plan, are provided by the same employer or same plan sponsor. Where you need to be careful is An employer may be covering spouses under an HRA, and that spouse is not in my employer's plan, but under their own employer's plan. Then you would have a reporting situation, because then the HRA and plan is not provided by the same employer. So again, a lot of little nuances going on that you really have to read the instruction and read the rules on it. Another interesting question, and we just got this question actually the other day. And again, it falls under the ACA requirement, and it says, do we qualify for 2015 transitional relief? Now, the first part of the analysis is that there were actually several forms of transition relief for calendar year 2015. So we have to find out what kind of transition relief is the employer asking about. And the other thing we also have to clarify is that because some employers offer a plan year that is different than a calendar year, we have to understand when that transition relief was applied. So the thing to be certain about is that if your plan year is an off-calendar plan year, maybe it starts in May and goes to April. Maybe it starts in July and goes to June. Then you could have still been eligible for some 2015 transition relief in 2016 because your plan year went into 2016. Now, my word of caution on this, if they were asking for 2015 transition relief as of 2017, the answer is definitely no, because again, the last time you could get transition relief was in 2016. So again, we want to talk about some types of transition relief that was available. There was transition relief for offering dependent coverage, and then transition relief for being a large employer, having at least 50 employees, but having fewer than 100 employees. And that's the transition relief that we're talking about now. Again, this transition relief was limited to the 2015 plan year. And what it said, that is, if you had at least 50 employees but less than 100, you only had to comply at the beginning of your next plan year that fell in 2016. So let's use my May to April example. So if your plan year started in May 2015 and you had 65 employees, you would not have been responsible for ACA compliance in January, February, or March and April of 2016 because you were still eligible for that transition relief. We looked at the plan year. But then your requirement would have started in May of 2016. So again, some tricky nuances going on there. So definitely not a cut and dry answer as to yes or no. You have to look at what kind of transition relief you're looking at and actually what year we're looking at, what calendar year, and what your plan year is. The next question that we have, and this one is pretty recent. It says, I'm a small employer, and I heard I can pay for individual insurance for my employees. Is that true? And actually, the answer to that is yes, but there's, again, a lot of criteria that has to be met and a lot of clarification that has to be provided. And why this is true is because we know that on December 13th, 2016, President Obama signed into law called something the 21st Century Cures Act. And what the general purpose of the Cures Act was to speed the discovery of cures for killer diseases, to fund research, to go ahead and buy new drugs and medical devices, and to improve mental health. However, buried on about page 950 of 1,000 pages, there was this section titled Qualified Small Employer Health Reimbursement Arrangements. And what this provision did is it brought back the ability for a small employer to offer a standalone HRA for its employees. Now, we know that disability was previously taken away by the IRS when it gave us notice 2013-54 back in 2013. And what the IRS has said, wow, remember, an HRA is a group health plan. So it has to meet all of the ACA requirements. And the only way it can meet the ACA requirements is if it's integrated with a group health plan. So, Mr. or Miss Employer, you can no longer have integrated, you can no longer have standalone HRAs. Well, again, the Cures Act has brought this back for small employers. Now, my word of caution is it's not the panacea that many of the small employers think it is, because there are, again, a lot of nuances. Why you can now offer this HRA for a small employer is because the Cures Act amended the Internal Revenue Code under the sections that defined what a group health plan is. And it amended it such that it said, under ERISA and under the definition of group health plan, no longer is included a qualified small employer HRA. It specifically uses that language. Now, since a qualified small employer HRA is not a group health plan, it doesn't have to meet the ACA requirements. Thus, that is why you can now go ahead and pay for individual insurance premiums for your employee. Some of the things that I mentioned here that I want you to be aware of, and we're looking at actually the fourth bullet, is that even if you sponsor an HRA for your employees to pay for individual insurance, your employees still have to make sure that they maintain minimum essential coverage, or they may be taxed on the reimbursement. So if you set up an HRA and you're a qualified small employer, and your employee can get reimbursements because they went to the doctor and they paid $50, or they went to the emergency room and they paid $500, but they're not covered under a minimum essential coverage plan, then they would be taxed on receiving that $50 or $500 from you. So one of your requirements is that you have to make sure that employee has MEC, or else you need to tax that benefit. Also, another thing that the employee has to be aware of, if the employee is receiving that individual coverage on the marketplace exchange, again, under your HRA, you can help them pay for it. However, any subsidy that they receive on the marketplace would be reduced by the amount of the HRA that you fund for the individual. So again, some nuances that we have to watch here, and they're very important because they would lead to tax issues for the employee. Also, as the employer, you're going to have some reporting requirements. You do have to put that on a W-2 beginning in 2017. And again, since this HRA is not a group health plan, it would not be subject to COBRA continuation coverage. On the next slide, continuing our conversation about this small employer qualified HRA. As an employer, you have to meet these conditions to go ahead and offer this type of arrangement. You can't be an applicable large employer. You have to be small. You have to have less than 50 or more full-time or full-time equivalent employees. My word of caution, remember, look for common control. You may say, yeah, I only have 20 employees here in this company, but the owner has another company that has 60. You're no longer considered a small employer because under the aggregation rules, under the Affordable Care Act, you'd be a large employer. The other requirement, you cannot offer a group health plan to any employee. So you can't say, well, maybe for our staff, we'll offer an HRA and let them pay for individual premiums, but for the management people or executives, we're going to go ahead and get them a nice, PPO or nice indemnity plan. You cannot offer any group health plan whatsoever. It has to be offered to all similarly situated individuals. So if you say full-time employees, that means all full-time employees. Only employer funded. Remember, the employees cannot make contributions to an HRA, either by giving you money or by making a salary reduction to a cafeteria plan. You can provide for the payment or reimbursement of medical expenses. So you can pay for premiums, or as I said, you can just go ahead and set up reimbursement. If you have a prescription drug, we'll reimburse you the money you have to pay for that. And then finally, you are limited. The maximum that you can make contributions for are $4,950 for an individual and $10,000 for family coverage. So again, some of you may be interested in this. Look at the requirements because, again, it's just not a panacea. It's not like, oh, yeah, we can do this again. You have to really have a lot of criteria that has to be met. So now we're going to go ahead and move on to some COBRA questions. And the first one we have here is, our company recently mailed a COBRA election notice by first-class mail, but it was returned as undeliverable. What should we do? Well, we know that under the COBRA regulations, and actually under the statute, it provides that the plan administrator is only responsible for mailing the notice to the qualified beneficiary's last known address. However, even though we know that the statute and the regulation provides that, there have been court cases on this type of instance. And the courts have really looked at it a little bit differently because the courts say, you know, we want to look at some different theories. And some of these different theories are, you know, first of all, your plan administrator responsibility. You're required to, you know, send out that notice and to try to do your best to make sure they receive the notice. So the court may say, well, gee, Mr. Employer, is there any other reason that you could have known that maybe they moved? Have you heard employees talking about them moving? Did they send you some other notice? What about the 401k plan? Did your 401k plan get notice of a change of address and you just didn't move that information over to your health plan? So again, you have to be very careful about just saying that I'm going to rely on that I sent it to the last known address and don't think that you could have any liability come back to you. Also, if a qualified beneficiary contacts you and says they didn't receive the notice, I think it would be very prudent and reasonable to go ahead and make sure you resend the notice. But what I would do is say, please make sure I have your correct address. In continuing this same question on the next slide, I've got a word of caution here. Many employers have the practice of sending a COBRA notice by certified mail. The employee or the individual has to sign for that letter, has to receive it. So what does the employee do? They just never go pick up the letter. Technically, they have not received their COBRA notice. That means you haven't provided it. So be very careful about certified letter. Requirement is send it first class mail. What you may want to do is get return receipt. Return receipt actually says we delivered it. Whether the person opened it up, it's not the, you know, the government's responsibility. Return receipts are nice because you do get that notice that it was delivered. So some other tips: create and maintain those written procedures. Talk about the steps that you took. Make sure that you're putting in your SPD and in your COBRA notices that it's always the responsibility of the qualified beneficiary to notify you of any address changes. The next question we have also comes under COBRA, and it says, geez, I recently sent a COBRA continuation notice to a terminated employee, and they have family coverage, and it covers medical, dental, and vision. But the employee said that she's going to elect individual coverage, but what if, she wants to know, can she add her dependents later if necessary or if she wants to? Now, under the rules, we know that if a qualified beneficiary, which a dependent would be a qualified beneficiary, if they don't elect the individual coverage during a COBRA election period, and if they're not enrolled under coverage under the former employee's family coverage, then at the time of election, then the dependents could only be enrolled during a future open enrollment period. They just can't be added on at any time. And if these dependents are enrolled at a later time during open enrollment, they are no longer qualified beneficiaries. They're just covered dependents. And what that means is they lose their rights to a second qualifying event, which could extend their COBRA continuation coverage. So that's an important consideration that dependents or other qualified beneficiaries always have to consider. Now, our exception to this rule would be if the dependent says, I don't want to be enrolled under COBRA because maybe now I have the other group health plan coverage. Maybe I've got employment somewhere, but then they lose that other group health plan coverage. We talked about this. This would be a HIPAA special enrollment right. And even under COBRA, qualified beneficiaries have special enrollment right and can come onto the plan outside of open enrollment. This next question gets is a little bit more detailed, but again, I thought it was an interesting one. So this employer said that they had an employee who went on long-term disability insurance. And they want to know, is that employee eligible for COBRA? And they did provide the facts that they normally cover insurance for short-term disability employees, but not long-term. Also, this employer has less than 50 employees. So we've already kind of alluded to this, that an employee is eligible for COBRA when there is a loss of coverage due to a qualifying event. And a qualifying event for an employee is a reduction of hours or a termination of an employment. So when an employee goes out on STD, that's definitely a reduction of hours. They're not working. And COBRA should be offered at that point. Now, we've already talked about some exceptions. It would be the same exceptions as workers' compensation. If we're subject to family medical leave, we'd have to extend that coverage. If we're subject to the Affordable Care Act, we may have to extend it. But this employer says they're less than 50, so those don't come into play here. Now, what this employer did is they left them on the group health plan, even though they probably should have been offered COBRA. Now, we've already talked about it. If the insurer would look at these, any type of benefits provided, they could have said, well, this individual wasn't eligible. We're going to take back those benefits. And again, the employer could have a little bit of litigation on their hands at that point. So again, if we're going to keep someone on the plan, the insurer always has to approve that type of practice. Now, this employer, what they did is they implemented their own policy. But a reminder, insurer has to approve it. So in continuing, this employee didn't lose their coverage when they had a reduction in hours. So their COBRA really did not kick in until that loss of coverage. In this instance, the loss of coverage will come when that employee goes out on long-term disability, and it is at that point that COBRA should be offered. So I think we're going to wind up our next set of questions talking about the Medicare secondary payer rule. And I like this question because this question tells me that the employer is really thinking about the MSP rules and how they apply. Because they ask, what's the difference between being eligible for Medicare and entitled to Medicare? And believe me, it does make a difference, because when we look at the regulations, the terms eligible and entitled, they're not synonymous under the MSP rules. An individual can be eligible for Medicare by virtue of age, 65 years old, disability, or having end-stage renal disease. However, to be entitled to Medicare, an individual must be eligible and actually enrolled in a Medicare program. So that's what the difference is. Entitled means I could get the Medicare benefit. Eligible, to be entitled to Medicare, an individual must be eligible. I have the right to Medicare, and then they must be enrolled. The next MSP question, if an active full-time employee who is turning 65 does not elect Part B Medicare, is he or she penalized? Talking about Medicare Part B, it gets to be a sticky situation, and we kind of just offer general information because, again, that's a personal medical situation and also a family situation because there is a cost to Medicare Part B. So the first thing that we have to talk about is if this person is an active full-time employee and they're turning 65, we we have to look at the size of the employer. Because if the employer has 20 or more employees, then that individual has the right to stay on that health plan. And the employer cannot consider what said take into account their Medicare age ability to be enrolled in Medicare. So as long as an individual is covered by a group health plan, even if they're 65, if they don't enroll in Part B, they would not be penalized when they do enroll because, again, they have a group health plan coverage, and that's considered as having coverage. Now, however, if upon termination, maybe this employee then quits, and they say, I'm going to go ahead and take COBRA. Remember, an individual has 8 months from the loss of their coverage under a group health plan to enroll in Part B. That's called their special enrollment period. And what Medicare says is that COBRA coverage is not deemed group health plan coverage for the purpose of Medicare secondary payer rules. So if I'm 65, I terminate, and I say, geez, I'm going to stay on COBRA for 18 months because it's great, and then I go to Part B, I will be penalized for every month after that 8-month period that I didn't enroll that I should have enrolled under Part B. So again, you have to be careful when we have a COBRA situation. If the employee has the right to be on the plan, they're actively employed, they're under the group health plan, they would not be penalized. It's when they lose that group health plan coverage and they don't enroll in Part B that they could be penalized. And that was the last of my questions here. So at this point, we want to go ahead and see if anyone who's been on the webinar has any questions. And actually, we have a couple people sitting with us in person today. Do we have any questions? They're shaking their head no, so that means we'll give it about 30 seconds to see if there's any delayed questions here before we terminate. As a reminder, our next JRG webinar will be on Thursday, February 9th, same starting time, 10 a.m. And the topic is going to be exploring the world of insurance. Discover the right coverage for your needs. Okay. Well, at this point, we don't have any questions coming in from those attending the webinar. So I want to thank you for taking the time out of your busy day to listen to the questions that you've asked about in the past. I hope you found the information helpful, and I look forward to speaking with you again. Have a good day. Bye.